QN. The purpose of this provision was to give AMI an opportunity to coordinate credit coverage arising relating to the announcement of this agreement, right? When you say credit coverage, to negotiate with financial institutions, you mean about notifying them? AU, well, do you remember? Well, that's the thing. I am a little confused when you say about credit coverage. Let's look to the next page, and please zoom in on the text. Do you see the reference to AMI's underwriters, auditors, or insurers for the limited purpose of negotiations regarding credit decisions? Yes, it advised them of the agreement. To give AMI an opportunity to protect itself financially when this was announced, right? Yes, and as CEO of AMI, did that happen? Did AMI make those communications and notifications? Yes, we did. You notified insurers and underwriters, correct? Yeah. And those notifications provided a copy of this agreement, right? I wouldn't know if the agreement was shared with them. But the substance of the agreement was disclosed, right? Eyes. And in connection with those disclosures, it was represented to the financial institutions that the agreement was factually accurate, right? Eyes. Because you know from your experience that in order for the financial institutions to make credit decisions, they need to have the complete information about the issue, right? That's correct. And so, you testified yesterday about a statement of facts attached to this agreement, right? Eyes. And if we can take a look at the next page, please. And this is that statement of facts, right? Yes, and it was incorporated into the agreement, correct? Yes, it was something that you approved as the CEO of AMI, right? Eyes, and it was something that, as a member of the board of directors, you reviewed and approved as indicated in the agreement itself, right? Eyes. Can we zoom in on paragraph 3, please? Now, you testified earlier this morning about the August 2015 meeting. Do you remember that testimony? Eyes. Do you remember that you confirmed that during the August 2015 meeting there was no discussion on catch and kill, correct? Yes, and during the August 2015 meeting there was discussion of a financial component to any agreement with President Trump and Michael Cohen, correct? There was a discussion about that I was going to be the eyes and ears of the campaign. There was a discussion that I would be notifying Michael Cohen of any women that were in the process of or going to be selling stories. I would notify Cohen that they would be available, and they would either have to buy them or take them off the market or kill them in some manner. Are you testifying now that there was a discussion of the kill agreement? Emerger Stanglass, objection. The court sustained. I said, sell a story. I would like to go back for a moment to the October 2019 meeting that we discussed a few times today, the meeting you had at the district attorney's office. Eyes. Do you recall that this provision of the agreement was discussed during that meeting? The August meeting you are saying? Let me back up and ask a better question. Do you recall that paragraph 3 of the agreement that's on the screen was discussed during the October 2019 meeting? Eyes. And do you recall that your attorneys told the district attorney's office, in your presence MR/STEINGLASS objection, judge. Objection. The court of approach. Discussion is held at side bar, on the record. Emerger Stanglass, so, he is trying to impeach the witness by what the attorney told the DA's office. I think that's totally improper. Mr. Judge, first of all, the attorneys are his agents, speaking in his presence, on his behalf and just the fact that he is aware of what they meeting. Said on this issue, they said to the district attorney's office this provision is inaccurate. Soits in addition, I will lay a foundation that no one reported this to the federal government. They had taken the position with the district attorney's office that the federal non-prosecution agreement was inaccurate. He has already said that he verified that it was accurate. The decision not to inform the federal authorities conferred a significant benefit to Mr. Pecker. On both those grounds these are entirely so appropriate. It happened in front of the witness, Hayes aware of COURT, and it is completely admissible. Mr. Stanglass will say two things to that. Number one, it's unbelievably confusing. I am not sure what sense the jury will make of that. Number two, I am not sure what the relevance of this is other than, we have confirmed that the attorney was mistaken in this recollection. The court, the issue, as I am hearing you describe, it is that I am confused, and if I am confused, I imagine that the jury is going to be confused. So, if you can get to this in some other way, we'll allow you to present, but the way to go about it, I don't think this helps us to get to it. What I would ask permission to do, Mr. Judge, is finish the question that I was asking, which is whether at the October 2019 meeting his attorneys told the prosecutors that the agreement was inaccurate. The court, and leave it at that. Mr. No, then I would confirm that, to his knowledge, that it was never conveyed to the federal government. The court, you can finish your argument. Ahead. Mr. It is a very significant benefit conferred on him by the district attorney's office and, please, I think this is the first its cross-examination as a defense lawyer I have ever done. Please do not hold my shortcomings in the way I am forming questions against President Trump. This is right at the core of what we are doing to impeach Mr. Pecker. The court, two things. One, you are doing a very good job. Two, that you may be doing a bad job in your opinion is of no consequence. Whoever the defendant is, whatever the position the defendant is running for, and whoever represents him, you are all being well compensated to come here and do a great job. To tell me not to hold it against your youth suggests that I shouldn't enforce the rules of evidence, and I am not going to do that. I will allow you to ask those two questions, and that's it. Beyond that, it will just get confusing. Mr. So I don't overstep, I can ask if he is aware that his attorneys argued in this meeting that the agreement was inaccurate. The court, now are you saying that he was there? Mr. Yes, and I would ask permission, if he doesn't remember, to refresh him. The COURT just ask him, and then follow up with the second question. Mr. That to his knowledge this was conveyed to SDNY. The court, yes, and leave it at that. Imar Bove, thank you, Judge. Discussion at sidebar concluded, and the following occurred in open court. By Imar Bove, thank you. Mr. Pecker, so, before the sidebar, we were talking about the October 2019 meeting, right? Yes, and I think we can put the non-prosecution agreement back on the screen, please. And I think before the sidebar you said that this provision, paragraph 3, was discussed during that meeting, right? Yes. And your lawyers were there, right? Yes, correct. Some of the same lawyers here in the courtroom today. Yes, during that conversation about paragraph 3, do you recall that your attorney said to the district attorney's office that part of paragraph 3 is, quote, wrong, and do you remember that? Inaccurate? No. Mr. Bernick, if we can show just the parties and Mr. Pecker and the court defendants A108. Let's start with the first page just to get oriented. Do you see that these are the notes from October 25th? Eyes, and you testified earlier about somebody in the meeting typing everything down, right? Eyes, and if we can now look at the page ending 047. Eyes. And if we zoom in on the first half, please, and I want you to read this, and then let me know when you are done and I have a question or two. And does that refresh your recollection that paragraph 3 of the non-prosecution agreement was discussed in this meeting? Yes, you can see that at the top, right? Yes, A, and the next entry is a statement by one of your attorneys, correct? Yes. And does that refresh your recollection that the attorney said in response to a question about paragraph 3, I think that may be inaccurate, I think that came up with the feds, I have never heard Pecker say that? Does that refresh your recollection that that was said during the meeting? No, and I would like to clarify it, if I can. A-okay. The only wording here is the word, purchasing, selling stories. Meaning? Meaning my testimony that I gave, and what I said was, I offered at that meeting that being the eyes and ears and hearing any stories that are there, I would offer that women would be selling them, and I would be offering them synonymous. Does that to Michael Cohen, that's what I said? So, the selling here and purchasing, basically, are somebody has to buy them. Straightforward. My question is a little more. I appreciate the clarification. My question is, in response to a question from a prosecutor about the provision in the non-prosecution agreement, did your attorney say, I think that may be inaccurate, I think that came up with the feds, I have never heard Pecker say that. Emerger Stanglass, objection. The court sustained. Yes. The court, the objection is sustained. I am sorry. There was a dispute in that meeting about some of the language in the agreement, right? Mr. Stanglass, objection. The court overruled. He can answer. Yes, it was just the one word. We can agree that words are important, right? Yes, that selling and purchasing is the same. Somebody is selling, somebody has to buy them. That's not what your lawyer said to the prosecutors, is it? Mr. Stanglass, objection. The court sustained. And as far as you know, after that October 2019 meeting, the district attorney's office did not tell the federal government that their agreement was inaccurate, correct? Mr. Stanglass, objection. The court sustained. And you testified on Thursday that you received a letter from the Federal Election Commission in 2018? That's correct. And you said that you spoke to Michael Cohen about the letter? Yeah, I did. And you said that during that conversation Michael Cohen told you that President Trump had Jeff Sessions, quote, in his pocket. Do you remember that? Eyes. Are you positive that Michael Cohen said that? Eyes. Q, and in thinking back in time to early 2018, you knew that wasn't right? That's why I said to Michael Cohen, I was very concerned and worried. You were concerned because Michael Cohen had said something to you that wasn't true? That's correct. Because President Trump did not have Jeff Sessions in his pocket, correct? Mr. Stanglass, objection. The court sustained. And, in fact, this was an example of one time that came to form your view that Michael Cohen is prone to exaggeration. Mr. Stanglass, objection. The court overruled. You can answer? I'm sorry, could you say that again? Based on your experience, Michael Cohen is prone to exaggeration. Eyes. You could not trust everything he said? Mr. Stanglass, objection. The court overruled. Mr. Stanglass, could we be heard at sidebar? The court, sure. Discussion is held at sidebar, on the record. Mr. Stanglass, sorry, Judge, I am not trying to be difficult. This is opinion testimony of a witness of the credibility of another witness who hasn't testified yet. To attack a witness credibility that is not proper. Witness credibility is being attacked for bad acts or a reputation for peacefulness, truthfulness in the community. The witness is not permitted to offer by another witness his opinion of another witness. Mr. Bove, the witness has been able to testify and give his opinion here today about President Trump's statements or admissions. The statements of Michael Cohen. The court, to the extent that you are asking him you need to move on his opinion, I am not going to. Discussion at sidebar concluded, and the following occurred in open court. By Mr. Bove, you testified yesterday that the FEC investigation actually ended in sort of an agreement with AMI, right? You want to impeach Michael Cohen, that is not the right way to do it. All right? Mr. Bove, yes, Judge. Yes, and I think you referred to that as a conciliation agreement, correct? Eyes. And that was entered into in May of 2021, if I am remembering that right? It was 2021, May or June. And you read that conciliation agreement at the time it was entered into, correct? At that time I was not part of the company anymore. You left in 2020, correct? I understand. That's correct. You were still interested in this investigation, weren't you? Eyes. Part of that was because you still had equity in AMI, right? Yes, and you also provided consulting services to AMI? Yes, what type of consulting services were you providing to AMI in 2021? Just any questions from the president on the tabloids, on the celebrity magazines, and the magazine issues. And for those reasons, among others, you reviewed the conciliation agreement, right? Ayes. And you testified yesterday, did you not, that the conciliation agreement involved an admission by AMI to a campaign violation? Ayes. That wasn't accurate, was it? Yes, Mr.Steinglass withdrawn. Yes, it was. Siritzaiu reviewed the agreement in 2021. You reviewed it more recently? I reviewed it in 2021, yes. Have you reviewed it more recently? More recently, yes, I reviewed it. Right? In connection with preparing for your testimony, yes, Mr. Bernick, if we can take a look at defense marked for identification A131, please, and turn to page 2. This is a conciliation agreement, right? Yes, and if we can look at page 7, please, Mr. Bernick. And I would like to zoom in, if we could, to the paragraph with the Roman numeral entry 5, sub 1 and 2. I have page 6 of 8. We will work on that. I think he's this A131? Ayes. There we go, sir. Take a look at the language that is zoomed in on the screen, and I want to see if that refreshes your recollection that AMI entered into this agreement with no admission as to the merit of the Commission's legal conclusions. That's different from an admission, right? One of the other reasons that you were following this FEC investigation was that you were actually a party at one point, right? Yes, yes. Ayes. Yes, yes, and you and AMI had counsel, correct? And the FEC was also accusing you of a campaign finance violation, correct? And you certainly did not admit to a campaign finance violation in connection with anything that you described during your testimony, right? And that conciliation agreement that we just talked about with AMI, you were not part of that, right? That was the company. Right. You didn't work at the company anymore, correct? Yes. And in connection with defending against the FEC allegations, you submitted a declaration to the FEC, correct? I did. That was on May 6th of 2021. Do you recall that? Yes, and you submitted that declaration under the penalty of perjury, right? Ayes. And in that declaration you described the legal advice that you had received relating to the agreement with Karen McDougal, correct? And the position that you and your lawyers took was that the agreement was lawful, right? Ayes. Yes. And there were certainly no suggestions in your sworn declaration that you withheld anything from your attorneys in connection with the negotiation of the August 2016 agreement? Mr.Steinglass, the court, objection. Sustained. Your position with the FEC was that you were completely truthful with your lawyers, right? Yes, and the attorneys argued to the FEC that that was part of the reason that you had not committed a campaign finance violation, correct? Can you repeat that again, please? You were represented by counsel in the FEC investigation, right? Ayes. And so was AMI, right? Yes. And it was the same lawyers, correct? Ayes. And they were making arguments on your behalf, right? Yes, and also on behalf of AMI, correct? That's correct. And they were arguing to the FEC that you had not committed a campaign finance violation, correct? Ayes. And you believed in 2021 that that was true, correct? Yeah. And that's why you authorized your lawyers to make those arguments to the Federal Regulatory Agency, right? Ayes. And you submitted a sworn declaration under penalty of perjury describing the facts, correct? Ayes. And in that declaration you asserted to the FEC, under Q penalty of perjury, that you sought legal advice relating to the August 2016 agreement with Karen McDougal, correct? Ayes. And your lawyers relied on that sworn declaration to argue to the FEC that there was no violation, right? Ayes. And you were familiar with the argument that they were making, correct? Ayes. This was important to you, right? Yes, similar to the situation with the FBI? Correct. And we have talked a lot about that the October 2019 meeting with the district attorney's office, right? Ayes. And after that meeting, your hope was that at least the criminal proceedings were over, correct? Yes, I thought it was over. And you wanted this civil regulatory investigation to get resolved also, right? Ayes. You were focused on it, correct? And you believed that what your lawyers were saying to the FEC was true, correct? Yes, and you are aware that one of the things that your lawyers argued to the FEC was that the Washington Post had suppressed information relating to Paula Jones in connection with the 1996 election, correct? Mr.Steinglass, objection. The court sustained. You were answering questions yesterday about some boxes relating to President Trump. Do you remember those yes questions, sir? And I think what you said was that there was a request from Michael Cohen to get access to these boxes so that he could look at what was inside of them, correct? That's correct. There was some suggestion by Michael Cohen that he was concerned about what would happen if you left AMI, right? Ayes.